Hello and welcome to the Monday Agenda. The Monday Agenda today talks to Professor Alexander Mizaev, who is a doctor of international law, who is visiting Tanzania at the moment. And we shall learn during the 45 minutes of the program his 1 or 2 weeks in Tanzania and understanding the context of international law. So, Professor, welcome very much to the program.
Thank you very much.
So tell us, what brings you to Tanzania this time of the year?
I work as the head of the Department of International Law at the law faculty in my university, but at the same time I'm also editor-in-chief of the Kazan Journal of International Law and International Relations. We publish this journal in Russian and in English. There are some special editions of this journal, and the special reference our journal has, it's Africa and Russian-African relations.
Okay.
So it will be very interesting for me to visit Tanzania and to learn more about this country and communicate with people from academia to give some lectures, some meetings, and hopefully one of the especially next editions will be dedicated to Russian-Tanzania relations.
Now, you've spoken of Russian-Tanzania relations. Is this in the context of international law?
It is, but at the same time, when we talk about international law, it is important to discuss this topic not in isolation. Because if you take international law out of the context, sometimes it will be difficult to understand.
Absolutely.
So that's why our journal was initially called Journal of International Law, but then we changed it and include and international relations.
Okay.
So we are considering international law now with the context of international relations. And of course, answering to your question, yes, Russian-African and in generally and in particular Russian-Tanzania relations in the field of international law, we should consider within the context of international relations generally. That's very important to understand.
As a professor, doctor of international law, how would you describe the relationship between our two countries, Tanzania and Russia, in that context?
Of course, I consider them as a friendly one. We have very similar approach to the main problems in international relations. But it is much important to improve these relations, to consult more, and to appear on international stages more often together with a common position. So I think it would be a very interesting event soon in Russia, in Sochi, in the end of October.
Okay.
It will be the first ever in the history of our relations, the Russia-African Summit.
Okay.
And I hope this summit will bring us to a new level to our relationship, because it's really time to intensify our relations.
Can we unpack the International Criminal Court in Africa, the context, so that our viewers of the Monday Agenda can understand the context of International Criminal Court and how is Africa fitting into that context?
International Criminal Court is not just an institution of international criminal justice with a limited jurisdiction. In fact, this is an institution of a global power. That's the main topic of my research, in fact.
Okay.
I worked with several international criminal courts and tribunals, mostly in International Criminal Tribunal for the former Yugoslavia. But now I'm also assistant to counsel in the ICC, or rather in the list of assistant to counsel in ICC, International Criminal Court. So the analysis of the work of this institution has a very big part in my academic and research and in my practical work. We should take the activity of International Criminal Court in the context of the international relations. And if you ask me what part of ICC in the modern world, I would define it as an institution of global power. Official name of ICC is International Criminal Court.
Yeah.
But the activity of this court gives us a certain facts that shows it is not exactly international. Because International Criminal Court constitutes at least of two institutions. It is international organization and it's international court. International organization is a so-called assembly of state parties.
Okay.
So in this part of ICC, the states could convene, could discuss matters, but this part of ICC rarely affect the activity of the court, or rather it's not affect the activity of the court, because the court is separate. And the activity of this court shows that the states are not really or directly affected the activity of this court. Because when you say international law, we mean interstate law, because the notion of nation is a state.
Yeah.
But when we come to the activity of ICC as a court, we can see that it's different actors are applying and even creating a law. It's fine for judges to apply law, but the recent activities of ICC shows that judges are starting to create law. So this is the
Judges are creating laws.
Judges are starting to create laws.
Okay.
So they disregard the existing norms of international law and creating their own norms, which is of course not law, but through the activity of the international criminal institutions as a system, it becomes law.
Absolutely.
Well, by the way, with the help of textbooks, which are mostly published by those states who plays a critical role in these institutions. So even through the legal education, these judges created law pushes as a law. So the idea of the creation of ICC, officially proclaimed goals of ICC, was the fighting with impunity, bringing to justice those who are most responsible for the commission of international crimes. But those goals, in my opinion, are not implemented in practice. So in practice, we are witnessing a very different agenda of this institution. For example, when we talk about the commission of war crimes, it's a very strange situation when the ICC and other international criminal courts receive the jurisdiction to investigate the crimes, the war crimes, to bring to justice those who commit war crimes, but don't have jurisdiction to the crimes against peace. So it's a very strange situation when the war crimes committed, but nobody interested who started the wars. And in this context, I would like to remind us about the historical events which, for example, now we have marked the 80 years for the beginning of the Second World War.
Yeah.
And to remember that historical event, it is very important for us, even in the context of today's events and future, because the victory in the Second World War was exactly that moment in the history when the international law started to change.
Okay.
Before the Second World War, the international law was very different. international law was on the side of the strongest.
The strongest.
The strongest.
Of course.
It was created by those strongest
Yeah.
in order to protect their interest. The weak countries were not considered.
Is it not still the case today? Out of curiosity.
No,
It's not.
I would say no,
Okay.
and I will explain why.
Okay.
Because it is always a problem of violating law, not implementing law in practice.
Okay.
It's one thing.
Mm.
So we should distinct between repressive international law that existed before the victory in the Second World War. And when I say victory, it was a victory not only of Soviet Union and the Allies, but for the whole humanity. And the violation of law.
Mm.
So you probably refer to the situation when the international law is violated.
The cases that have been presented to the ICC have mainly been of African origin. Are we saying that Europe, US, and other developed nations are not, violating laws at the attention of the ICC? The most recent that I could refer to is the deputy vice president of Kenya, for instance, and post-election violence. The other one was Liberia president. So these cases have again, I could be limited with scope to as far as the ICC's role and mandate is concerned. But when you rightly said that the initial initiation of the ICC was to protect the interests of the superpowers, the big nations, then it brings to my attention, it brings to my mind that is it still not the case? Because we've not had the likes of, a president or some leader from strong nations who are violated. And it's not like they're not violating. Post-election conflicts, misunderstandings, etc. happening everywhere in the world. But why do we see only in Africa that draws more attention?
Let me clarify my
Please.
answer. When I said that before the victory in the Second World War, the international law was repressive and defend the interest of the strongest. And when the international law changed to progressive, we have to stress out that this situation lasted to the beginning of 90s.
90s, okay.
When the international law was keeping development in a progressive way. But it is exactly after the destruction of Soviet Union and the socialist camp, the situation changed. And we are witnessing the situation when the new generation of international criminal courts were created. Then it was a long time without any international criminal tribunals in the world. And then, exactly at that time when Soviet Union was destroyed in the beginning of 90s, the new criminal tribunals were created. And the situation changed.
Okay.
That's probably what you mean, because
Yes.
now we have, still have the progressive international law. But this international law is under attack. So it's not like the strongest are applying repressive international law, but now they have to destroy it in order to pursue its interest.
Okay.
And I think it's important to stress that now we still have progressive international law. Why it is important? Because we have to defend it.
Mhm.
The progressive international law was a very special value of the humanity. It was created for a long time, and it has to be defended because it is exactly ICC and as international tribunals. When you refer to the case of former Liberian President Charles Taylor,
Yes.
it's another tribunal. It's not ICC. It's a special court for Sierra Leone. But you rightly put it in one context because being not officially subordinated to each other, international criminal institution, in fact, acting in absolutely the same direction. And sometimes they're violating the same rules of international progressive law and creating their own law again in a very similar way. You're very right, noticing that the activity of ICC nowadays is sharply anti-African. So, in the 11 situations officially in the ICC doc now, is all African, with one exception. It's situation in Georgia. But all the rest is African. So the African states legitimately asking questions why it is so.
Yeah.
Why this institution is not paying attention to other situations. And if we compare with, for example, investigation in Central African Republic and in Afghanistan, so the situation is very different. In Central African Republic, it was an internal conflict, but in Afghanistan, it was international conflict with the involvement of the great so-called powers.
Again, Kenya was internal conflict.
The Kenyan case, exactly, very internal conflict of very limited extent, but it was chosen to be a part of investigation. And let us remember how it finished. I'm sure you remember when all mass media put this case as Ocampo 6, when the former prosecutor of ICC presented the case against, or rather indictments against 6 accused.
Yes.
And then finished with Ocampo 0, which is a total disaster to the prosecution. Because these cases were lasted for several years and then finished with the acceptance of the fact that prosecution doesn't have witnesses. Not evidence, but witnesses. They claim to have evidence, but they never present real evidence. By the way, it's interesting that we talk about what prosecution has. In fact, if you read the indictments of International Criminal Court and other international criminal institutions, usually I call them stories, and not only me, but many defense lawyers, they call those indictments as stories, because there is no real evidence presented at the time when the indictments are issued. Officially, the standard of proofs for the indictment level is the prima facie on this level. But nobody knows what means prima facie. Or the translation from Latin is on the first look. But how you could arrest a person thinking that this person may be committing a crime on the first look. There's no definitions of what should be included in such a standard of proof, if we even could make it call as a standard. It's something so unclear. But even for the level of judgment, it is the same situation. Well, the standard of proof is different. Now it calls beyond reasonable doubt. But the situation is the same in a sense of no definition for such a standard. And if you look into the recent or not very recent judgments of the international criminal courts and tribunals, you could still ask a question: what is included exactly in this standard? Because some judges could say that the accused is guilty, and the case is proved beyond reasonable doubt. But other judges voting against this decision. So the question is whether those judges are not reasonable, if they are not satisfied with this standard. So unclearness, lack of definitions is some kind of very sharp feature of the ICC and other international criminal tribunals.
Because of unclarity, justice has not been rendered to certain groups, and certain groups who probably understood the details and the nitty-gritties, then have been able to walk free because they know. Is it correct to say that?
Well, when you say about groups, I think it's the only group which is affected by this unclarity of ICC is accused.
Yes.
So the accused, they really don't know from the beginning in what they're accused, for example. Because, let me give you another example of unclarity. Some indictments, they include the alternative charges. So it could be, I accused you in a war crime, or complicity in a war crime, or aiding and abetting to the war crime. And it looks like a prosecution doesn't really feel ready to prove either of these accusations or either of these charges. But the same situation with judges. For example, judges are absolutely free to conduct a trial for any time they want. It could be 1 year, 2 years, 10 years. There is no limitations how long you could keep a person in prison. And by the way, even acquit a certain accused after 10 years.
Wow.
Without compensation. Even if a certain accused found guilty, what could be a possible punishment? The same absolute unclarity. There is no any specific rules. It could be life imprisonment, it could be 1 year, it could be 5 years. So it's a game. By the way, this is actively discussed in the academic literature, but this situation is known in all these international criminal tribunals. Sometimes we have a guilty judgment with the life imprisonment imposed on the accused, and some judges claim that the accused is innocent. So to take the activity of the international criminal tribunals, and ICC specifically, sometimes we could say it's a total mess, it's a total legal mess. Even if we take the activity not of ICC, but some of other institutions, like the Special Court for Sierra Leone, the famous Charles Taylor case.
Yes.
Let me draw your attention to the very pronouncement of judgment. When Mr. Taylor was proclaimed guilty, at one of the judges at the panel claimed that he never was involved in the drafting of the judgment. But even if you try to take your own decision and look into the evidence that were presented during Charles Taylor trial, it was quite an astonishing situation. What kind of evidence were not only presented by the prosecution, but accepted by the judges?
Okay.
Let's say one of the star witnesses in the Charles Taylor trial was famous, I'm not sure, in what, Naomi Campbell, I just remember the name.
Yes.
I think she's a model.
She's a model and a designer.
Yes.
Yes.
So she was a witness in the trial, and her testimony was something like, when she was in South Africa in the hotel, somebody knocked to her door in the night. She opened the door and somebody given her a diamond, and she was sure that it was from Charles Taylor. Such an irrelevant, okay, we could guess the relevancy of such a testimony, that Charles Taylor was involved in illegal trade of diamonds. But it was such a story that proves nothing, or rather prove the unprofessionalism of prosecution, bringing such a witness. But in fact, such a witnesses very nicely proved the definition of show trials. Because in many cases, the show trial is the aim of the international criminal courts. Because in most of the cases, the international criminal courts and tribunals, they are considering the political cases. Most of these cases political, and the reasons for a certain conflict or political situations, they were already announced in media. Very often, the tribunals exist just to prove the already made statements by politicians, and thus they are confined only to a show trial, just to sanctify the already made decisions.
Now, to understand all these gaps, is it politically correct to say that ICC is not a global governing body because of all the gaps, all the shortfalls of the ICC, all the shortfalls in the translation and the definitions? Is it politically correct to say that ICC does not fit to be termed as the global governing body?
Taking the international criminal courts and tribunals generally, and ICC in particular, I could say that there is very little in them which is legal. So the names are courts or tribunals. They claim that they're international, but I don't see either in them. Not that they're courts, true courts, or truly international. Because even if we take a judgment, we can see that in many cases the judgments are not reasoned. So the legal reasoning either are very defected, or sometimes there is no legal reasoning at all. Let us give a very recent example of situation in Afghanistan, when the prosecutor of ICC asked the court judges to allow here the official investigation, and the judges said, no, we are not allowing you to do this because it's not in the interest of justice. But this is not satisfactory at all. But let me assure you that most of the reasons presented in the ICC and other courts decisions suffered from such poor reasoning or no reasoning at all. And by the way, there is a very interesting fact that probably not very well known. It's not a secret, but it's not very well known, that several judges of ICC don't have legal education.
Legal education?
Yes.
And these are judges of ICC?
And they're judges of ICC.
Okay.
It's quite surprising, right?
It is. I'm shocked. I'm shocked. I'm shocked because, as you rightly said, you're not seeing the international bit of it, and yet this is an international criminal court.
Yeah. But if you take the ICC not as some kind of ideal, some kind of institution with the officially proclaimed goals, but as a real institution with totally different agenda, then this fact will be not surprising. Because in ICC, what is the most important? It's not the legal reasoning. It is important that the right decision, or the decision that you have to take, will be taken. So it's not about your legal education. It's about your political affiliation.
If you like your legal education, then how are you positioned to give the right judgment?
The right judgment. When I say right judgment, I mean that outcome of the judgment that is politically motivated. Yeah. So it's not about law. It's about to implement a certain orders.
Okay.
Yeah. But you're asking quite an interesting question, because who is writing judgment? It's quite an interesting question. Because some years ago, it was a very interesting article published by the long-time standing registrar of International Court of Justice, who claimed that the judgments of this court for at least 20 last years were drafted by him. So judges supposedly just agreed with his drafts. Let's set aside whether that's true claim or not, though it was not rumors, it was the article published in a highly respected Leiden Journal of International Law. So it's a serious testimony. But setting aside whether it was true or truth or not, it's still a question who is drafted the decisions. And it is not a big secret for those who work with international criminal tribunals that it is indeed sometimes a staff of the tribunal who drafted the decisions. Probably it's not exactly for the separate and dissenting opinions of the judges, but for the majority of majority judgments, it's often the case. It's often the case. So you don't really need to be to have a legal education to be a judge in ICC. It doesn't mean that I welcome such a situation, of course not. But I'm just trying to explain that there is nothing illogical in this situation when you realize the real agenda of ICC.
You are watching the Monday Agenda, and with me on the show today is Professor Alexander Mizaev, who is the Doctor of International Law, and we're looking into the context of international law in the global context, but we're looking onto international law and the relationship between our two great nations, Russia and Tanzania. We're also looking onto the issues surrounding the international law, and my understanding, which I hope you, my very valuable viewer, appreciate the fact that we also dig a little bit onto understanding the issues of the ICC. But right now, let's look more onto the international criminal justice today, in the world today. What does it entail? There have been so much development across the globe. There are issues of, communication, ICT, lots of, we hear of, things like offshore accounts where people deposit money. There could be public funds. But again, this is your field. What does international criminal justice in the modern world entail? What are the details of international criminal justice today?
Let me again refer shortly to the history. The first international criminal court ever that were created was the Nuremberg Military Tribunal in 1945. Then it was a Tokyo Military Tribunal created next year. These tribunals worked very shortly, 1.5 to 2 years. All the cases were finished. And then, around 50 years, there was any single international criminal tribunals. So the creation of the new criminal tribunals was again revived in 1993 with the creation of International Tribunal for the former Yugoslavia. Next year it was a tribunal for Rwanda, and then it was a series of new international or internationalized international tribunals. In 1998 it was the ICC created. But the creation of the Permanent International Court did not stop the creation of the tribunals that were created for special situations. So even after the ICC creation, it was new tribunals. Until now, until even last year, a new internationalized criminal tribunal created. So we are indeed witnessing a creation of a system which is officially not subordinated to each other. For example, ICC is not reported to ICTY, ICTY is not reported to ICTR. There are some connections, but no subordination. The decision of the different courts not obliged each other.
Okay.
In the same time, if we look in more details how these courts cooperate with each other, we can see that in fact there is a coordination, unofficial but very strong one. And to this moment we could see that neither of these international criminal tribunals, they reach the officially proclaimed aims.
Okay.
For example, International Criminal Tribunal for the former Yugoslavia, the officially proclaimed idea was to help the mediation of the conflict. But in reality, the activity of this tribunal was in fact incited more and more anger.
Wow.
Partly it was made by accusing only one side of the story, of the conflict. But it was again not surprising, because those who voted in the Security Council for the creation of this tribunal were exactly those states which started the war. And it brings to the situation where the fair trial is not possible as such, without even reading judgment. Look at the case of former president of Republika Srpska in the Bosnia and Herzegovina, who was judged by the judges who were the citizens of the countries that waged war against his republic. Or look at the case of General Mladic, whose forces were bombed by exactly those countries whose judges are sitting in his trial. And any attempt to force those judges to be removed from the case, any attempt to disqualify those judges, finished with nothing. Though those judges were obliged to rescue themselves from the case. Again, it is understandable why, because those judges were especially interested in a certain outcome of the case. Because to convict a person whom you bombed means it washes you yourself from your outcry.
Yeah.
And let me remind you that President of Tanzania, Mwalimu Nyerere, he called that Yugoslavia war as absolutely a legal war. So when we talk about the creation, the real aims of the creation of those international criminal tribunals, we always see the political reasons. So the politics is an inevitable part of the international criminal courts and ICC particularly. So that's why I think that finally the African states took a very right decision not to try to reform the court, because it was such an attempt. Specifically, Kenya tried to present a certain changes for the ICC statute, and they took a politically correct decision. Now I probably can say that it's politically correct.
Yes.
But again, from the legal point of view, that it should be a collective withdrawal from the ICC. That was a common decision of African Union. Probably as an expert in law, I could say that legally speaking, it is not possible to withdraw collectively, because African states, they are individual members, so they signed on behalf of the country. But the reason why it was this decision was taken as a collective withdrawal is important, because these individual withdrawals, legal individual withdrawals, should be made politically collective, showing the common position of African states. Because Africa, as well as the whole progressive world, could be heard, it could be successful only if we are acting in common, which is ours. And let me also draw your attention to the fact that Russia very much supports this position of African states, and even in Security Council, it was only Russia request made by African Union to postpone the Kenya case several years ago. all the Western countries voted against,
Yeah.
though it was not a matter of principle. It was just a postponement for 1 year.
Yeah.
But I think it could be a good lesson for those who say, let's correct ICC, let's try to stay for more time. That situation when the West was not able to support African Union, even for this minor matter, it's a good lesson for such an expectations.
Absolutely. Professor Alexander, we've really, I mean, this content is very rich, but unfortunately time is not with us. But I wouldn't really wish to finish the program without, touch basing a little bit about your role as the director of Museum of African Art. Other than, international law, Doctor of International Law, and then you're also the director of the Museum of African Art. Quite two fields apart.
Not at all.
Not at all?
Not at all, because,
Okay.
because the international law and international relations could develop in different directions. It could be misunderstanding between people. It could be a hostile relationship, and it could be friendly relationship. And friendly relationship and progressive relationship, they based on many things, including culture.
Yeah.
Culture unites people, but you need to learn, you need to understand, and it comes with time. And I think that art is specifically that channel that allows people to understand each other, to find similar things, to find different things,
Mm-hmm.
but both similar and different things amazes you. And African art is indeed a special world. And when I start my own collection of African art, it was a beginning of the Museum of African Art in my university.
Wow.
The museum is still small, but it is the only university museum which accessible to everybody. Of course, there are some collection of African art in different universities, but they're not publicly accessible. They, in most cases, kept and unreachable for the general public.
Okay. All right.
So the African art, it is indeed that something that could help us to understand each other better, and us to help us to develop international relations and Russian-African relationship better.
Maybe as the last note, you've brought with you two journals that you've authored, or you've co-authored. Do you want to say one or two things about them, and then we close off the program?
Yes, this is the regular issue of Kazan Journal of International Law and International Relations. This specific issue is dedicated to Patrice Lumumba, and it was issued in the marking of 90 years of his birth. This is the only journal in international law and international relations in Russia with a special reference to Africa. So each and every issue is full of African events. So my colleagues sometimes ask me, why so much Africa? And I respond, why so much America in your journals? And this is the special issue of my journal, which is completely in English, and we are trying to make a special issues dedicated to a certain events. For example, the centenary of African National Congress of South Africa. This issue is a special edition prepared by Russian and South African associations of international law. We are very proud to say that very high officials given us an exclusive interviews, including President Thabo Mbeki, some former prime ministers, acting ministers for foreign affairs. So this journal is dedicated again to the better understanding of Africa in Russia and Russians for Africa.
You were watching the Monday Agenda, and with me was Professor Andre, who is an exceptional person, and we spoke about international criminal court, international court of justice, the issues of international relations in the legal context between Tanzania and Russia, and a little bit spice and touch of African culture, as is spearheaded the only museum, African museum in Russia. University Museum in Russia. Thank you for watching, and thank you so much for coming to the program.
Thank you very much.
Until next time, I'm your host, Austin Makani. Stay tuned.